to join in service, and I am praying for, my lord, the salary in the interregnum.
Appeal.
Ajit, he can accept service. He is appearing.
Any appeal has been preferred. September.
Can you record that he can accept the service? And
He appeared for the respondents in the read.
no, he is appearing in the content application. My client has served that. Ignore that. He is appearing. He can accept service. Record that.
Ashwin. This is an application alleging willful and deliberate violation of the order dated September 5, 2024, passed in WPA 589 of 2024.
Seasoned lawyer.
The petitioner is directed to serve a copy of this application upon the Mr. Basu, kindly hear
No,
this.
my lord, no. I am wrong. I have briefed late. But my lord has passed an order for service.
Yes.
Oh,
11th of December.
then my lord kindly accept the affidavit of service. Not the first time. Oh,
Pursuant to the service is appearing.
appearing.
Yes, what is your instruction?
একটু পড়ে বল সেই কাগজ ধরিয়ে দিল
দাঁড়াও ও সিনিয়র আমি একসঙ্গে বিক্রি পেলাম
This is the statement of facts. I'm not on the state. What has been done? Have you complied with? Forwarded to the Madrasa Education to initiate disciplinary proceeding. Is not in a position to grant relief to the petitioner. Are you placing this today?
Accept it.
Are you placing this today?
Accept it. And issue a rule.
Without looking into your handing of up papers before the court. If you are placing this, I can take it and
Placing it. Live streaming is going on.
please go through the papers before handing up papers before to the court.
They are now contemplating a proceeding, disciplinary proceedings. But in the Indiagram, none.
Ashwin. Affidavit of service filed in court today is taken on record. Stop. The alleged contemnors or contemner?
Contemnor.
One. The alleged contemner is represented by the learned advocate. First up. Yes. When do you want?
2 weeks.
Me. So you.
As your lordship wish. I will
pay
call
me?
for
Some submission.
I will call for the report.
What report?
The learned advocate appearing for the alleged contemner prays for time to take necessary
Honorable
instructions.
judge prayed for time, grant time, not prayed for time.
Prayed for time to take instructions as to the steps, if any, comma, steps, comma, if any, comma, taken pursuant to the order dated 5th of September 2024.
Well, at least something from the alleged contemner who is appearing, he should say something. Nothing. My lord's order is also vague like anything.
Mr. Basu, don't compel me to make something.
Can you see your lord's order? Can you hear what my lord had written? This is also on ifs and buts, this, that.
Kindly pass over the matter. Mr. Banerjee will be appearing in this. AGP Shobhan Banerjee will be appearing. He is leading me. That will be.
So press for time to take instructions. Take instructions in this matter. Take instructions in this matter. So stop. Yes. When do you want? At least say that.
Next Monday.
Next 2 weeks, my lord.
I am out of salary. I can't serving.
2 weeks. You are having the copy of the instructions. I have returned it to you. I could have taken cognizance of that.
And I will jump up immediately.
List this matter. Next Thursday, under the same heading.
My lord, that order, the pendants of the proceeding will not prevent them to release the salary.
I have not passed any order.
No, your lordship has passed an order in the writ
Faster to
application.
take instructions.
Yes.
I've not restrained them.
No, not restrain. There is the court decision of the matter. I will not release.
Pendency of
There
the
are-
contempt
yes.
application shall not prevent the
To
alleged
comply with the order.
contemners from taking steps in terms of the order dated 5th of September নাকি সেটা বলে দিন।
Grateful.
Lordship, one indulgence is required. Lordship, I mentioned today, Lordship has the urgent determination of Honorable Justice Sampa Sarkar.
Madam, where were you? Leave was granted to mention.
Lordship,
Now the officers are not here, they have left. It's
Lordship, when I
Take
came,
your
it
time.
was 2:01. Lordship, my interim order has expired. Yesterday, I had mentioned before Justice Sarkar.
interim order has expired.
I indicated yesterday that
When it has expired?
yesterday. So
Yesterday.
Lordship, I directed it will come up today in the list. It is as
Your other side.
other side is.
You intimate,
I will intimate. Lordship can.
come at 3 p.m.
Okay. Much
to
obliged.
break
Lordship.
in. What is the hand over the slip? আচ্ছা একটা লিস্ট পাবলিশ করতে বলুন অরিজিনাল সাইট কিন্তু এটা লিস্ট Yes, call the list.
Item number 6.
Item number 6, my lord, I am appearing for the petitioner. My lord, kindly see the operative portion at page 41, paragraph 49,
Contempt application.
contempt application.
এত মোটা কেন শুধু কন্টেম্পটাই দিন না
Contempt application টা দিন না।
Page
41, para 49. Time limits has been specified.
who is the alleged contemner?
My lord, 3 persons, the collector North Howrah, and my lord, the district magistrate Howrah, and my lord, the Partho Pratim Sadhuka special land acquisition officer. These are the 3. Now, my lord, I must confess, my lord, one thing, my lord. We have served with copy of an application for stay and appeal, but that appeal none by the state officer. State is not aggrieved by the order. KMDA against whom no direction has been passed, they have filed anything.
But the appeal is pending.
Appeal is pending, no doubt. But the government did not prefer any appeal. There is no direction against the KMDA. But I must confess, because since it has been served,
No.
we
So
must confess. But my position, let us have copy of the application upon the contemners.
petitioner is directed to তার আগে লিখুন, this is an application alleging willful and deliberate violation of the order dated of the judgment and order dated
23rd
August 23, 2024, passed in WPA 10244 of 2016 with FMA 24. No, only this. I think the others have been disposed.
My lord.
There was only one writ petition in which order was passed
Yes, yes.
in WPA 10244 of 2016.
2016.
2016,
Yes.
full stop. Petitioner is directed to serve a copy of this application upon the তার আগে লিখুন Mr. Beral Arnett, senior counsel, appearing for the petitioner, in his usual fairness, submits that an appeal has been preferred against the said judgment and order by the Kolkata Metropolitan Development Authority, but no appeal has been filed by the state of West Bengal. Full stop. Petitioner is directed to serve a copy of this application upon the alleged contemners by speed post with acknowledgement due and file an affidavit of service on the next occasion. 3 weeks.
3 weeks.
After 3 weeks, under the same heading. Yes. Next. Yes.
46.
Lordship, the petitioner before your Lordship, he was acting, holding the post of cashier of Bongio Gramin Vikas Bank.
Who is
He-
appearing for the bank?
Mr.
Oh, you are
Hossain is
appearing.
Lordship, the appellate order of the disciplinary authority as well as the appellate authority is under challenge. This is the second round of litigation. May I tell your Lordship the background of the case? He was holding the post of cashier on a morning at the beginning hours of the day. The inspection team of the bank came and they found shortage of 2,05,000 to the cash vault. The petitioner, as per advice of the then branch manager, he admitted that he has taken the money. Ultimately, on that day, somebody else paid that amount. On the basis of his admission, he was found guilty and order of dismissal was passed.
Not dismissal, removal from service.
Removal from
It
service.
shall not be a disqualification for future
Disqualification for-
employment.
The order was appealed before the appellate authority. Appellate authority upheld the order of the disciplinary proceedings. I filed a writ petition challenging the order. Honorable single judge was pleased to dismiss my writ petition, against which I filed an appeal. That order of the appellate division bench is, your Lordship, at page 44.
44.
Yes, this is the order of the division bench. The relevant portion is at page 48.
Yes.
May I just read the portion, page 48. We set aside the impugn order as well as the enquiry report and all orders passed pursuant thereto in the disciplinary proceedings. The bank will cause immediate fresh enquiry in the matter on disciplinary proceeding from the stage of charge sheet. Lordship, this word is very important. So whatever my admission was prior to the charge sheet, that will not be taken into consideration because all this was set aside.
No, I could not follow.
Because
The admission
that I took the money for my
prior
personal
to the charge sheet,
prior to the charge sheet.
why it shall not be taken into
Lordship, kindly
consideration?
appreciate. The bank will cause immediate fresh inquiry in the matter on disciplinary proceeding from the stage of charge sheet.
Yes.
So when the charge sheet was issued, the proceeding will continue from that. All other, Lordship, kindly see, inquiry report and all other order pursuant thereto in the disciplinary proceedings are set aside. The first line we set aside.
Yes.
So earlier admission, that will not be considered.
Why? Earlier, anything prior to the charge sheet, why it shall go?
Because,
remain.
no, Lordship, the thing is, in
From
the
the charge sheet, subsequent, everything goes. Not anything prior to that.
prior to, I am submitting that prior,
Not anything prior to that. That will remain.
but
And according to you, the admission is prior to the charge sheet.
yes, prior to.
So why
So-
that will go? It is from the stage of charge sheet.
Yes, we, Lordship, may I just,
The point.
Lordship, no, there are other points. The person who has subsequently passed the order as the disciplinary authority, he acted as the appellate authority and upheld his own order. Lordship, kindly come to the order impugned. The order of the disciplinary authority is at page 95, the concluding part, where the authority has put his signature. Page 95, your Lordship has got it?
Yes.
At the bottom, disciplinary authority and assistant general manager,
Yes.
sponsor
Show me
bank,
the order of the appellate authority.
Lordship, kindly deputed as general manager. So when he passed the order, he was acted as the general manager of the Gramin Bank. Although he was holding the post of assistant manager in the sponsored bank, but in the Gramin Bank, he was acted as the general manager. And Lordship, kindly come to page 100, the order of the appellate authority. Appellate authority and general manager. He was deputed as the general manager and acted as my disciplinary authority. When the appeal was preferred, he himself assumed the charge of appellate authority and
Which is the sponsored bank?
Lordship, initially it was UCO Bank or
UCO
UBI.
Bank is the sponsoring bank.
Yes.
Not UBI Bank. UBI.
UBI, United Bank of India. He was holding the post of assistant manager in UBI, but he was deputed as the general manager in Bongio Gramin Vikas Bank.
Show me the rules. Show me the rules with regard to these disciplinary proceedings.
See, disciplinary proceedings, presently I do not have a copy of the rule. Possibly Mr. Mokaram Hossain has.
Yes, Mr. Hossain, how can it be? Same person acting as the
My lord,
disciplinary
that point has
authority.
already been settled by the division bench of the Honorable High Court, my lord, on allocation on different matter, my lord. That the principal question is that, my lord, at the time the issuing the, my lord, charge sheet, in terms of the rules, my lord, the person was who and the appellate authority subsequently became the other person. The only question is that, my lord, whether the incumbent was given chance of hearing or not, number one. Number two, in terms of the subsequent amendment.
The appellate authority has to be an authority higher than the disciplinary
Absolutely.
authority.
And in terms of the.
Here it appears the self-same person.
No, not at all. My learned friend is
Yes,
submitting.
he's the
Yes.
general manager of that bank, general manager may be a different person.
Whether delegation of power was that or not, that is the question. I am handing over one decision, my lord, of this Honorable High Court, my lord.
Show me the rules first.
I am
show me
saying
your rules.
that everything has been covered, my lord. I am showing your lordship, my lord. Kindly see, my lord.
The reported judgment or unreported?
No, reported.
Reported judgment. Give him the citation so that he can also.
Yes, নাম্বারটা বলুন তো unreported দেখাচ্ছেন
Unreported.
Show me that point only with
Matt.
regard to this jurisdiction.
My lord, kindly see my page 10.
10.
Page 10, paragraph 3.
Paragraph 3, yes.
The general manager of the respondent bank, acting as the disciplinary authority on May 5, 2016, passed the order of punishment for the removal of the applicant from service without disqualification for future employment. The applicant, in the aforesaid writ petition, challenged the legality and propriety of the said order of punishment entirely on the grounds that the Service Regulation 2010, of which the applicant is the subject, does not authorize the general manager to act as a disciplinary authority of the applicant on May 3, 2013. That is the date when he assumed the charge. Now, the said authority vests upon the general manager only after the amendment of the Service Regulation 2010, with prospective effect from November 20, 2013. The other limb of challenge to the said order of punishment was such and such that the right of the applicant to prefer an appeal against the order of punishment has been taken away in as much as the amendment of the Service Regulation 2010. The chairman of the bank who issued the charge sheet has become the appellate authority. So after subsequent,
It's a different authority. Kindly
Yes.
see.
kindly see.
It was the general manager and is the chairman.
Yes.
The same person.
But
In your case, is the same person.
No.
In this case,
Only
the
point-
general manager acted as the disciplinary
Only
authority.
point before Lordship Manor, whether the appellate authority was the
Show me
same
your
person or
regulation.
not. Whether
Show me your regulations.
I'm showing, madam. Before that, kindly.
Decision does not help you.
No. Everything has been dealt with. Everything has been dealt with. My lord,
That
yes, I'm reading.
same person can act as
No,
the
not the
disciplinary-
same person. Whether the same person was the appellate authority or not, because before the appellate authority, the person was another person who considered the
Maybe the person has
and
changed,
higher rank.
but the designation, whether the general manager come
Lordship,
on the designation,
Lordship,
when he acts as a disciplinary authority, a general manager may be a different person, can be the appellate authority.
yes.
Show me
yes,
the regulation.
That is that.
Show me
I am
the
showing the regulation. Before that, madam, I'm just Lordship, kindly sit for a moment. Madam.
yes.
The division bench of the judgment under review has also answered the second ground of challenge of the applicant, holding that there was a change of personnel in the office of the chairman. As such, the appellant can have no apprehension of the same
It
person
was a different thing.
being the appellate authority.
The issue in
No,
this,
his issue is that, my
Mr.
lord,
Hossain, the
Lord.
issue in this was charge sheet was issued by the chairman.
Lordship,
In the meantime, the person holding the post of chairman has changed.
Lordship.
So chairman being the appellate authority can do that.
Yes.
That was the issue. But here it's on a different issue altogether.
No, I'm pointing out that issue. I am pointing out, my lord. Parawise, I'm pointing out.
Seen the facts of this.
I am pointing out. And the division bench in this judgment, my lord, kindly see, under review, has also answered the second ground of the challenge of the appellant, holding that there was a change of personnel in the office of the chairman. As such, the appellant can have no apprehension of the same person being the appellate authority. The applicant, instead of availing the opportunity granted to him by the appellate court, is seeking review of the judgment passed by the appeal on the same grounds which was canvassed in the said appeal to impugn the judgment of the learned single judge. The applicant has set up the consequence of the exercise the liberty granted to him, the appeal court, and to respond the inquiry report.
This was in review.
Review was made on that score. Yes.
Yes, I've seen that.
The grounds of which the applicant is seeking a review of the judgment passed in appeal are beyond the scope of such and such, my lord. And para 8. And for a moment, my lord, para 8, page 16. The rules has been discussed here also, my lord.
Para
16 onward, page 8.
Page 8.
Lordship.
Yes, paragraph 16.
Onward. In the judgment under review, this court has dealt with the submission made by the land councils for the parties and concluded.
Yes,
that,
Mr. Hossain, do you have a copy of the regulation? Let's be first.
Lordship.
If you're on facts, thereafter I will look to the judgment. Show me the regulation first. And this was the judgment passed in review. Where is the original judgment of the division bench? Show me that.
That is at present, that is not with me, my lord. And another point is
review, Mr. Hossain's scope is very limited.
Limited, but the point covered by the review court, my lord, everything has been covered. If he is not...
All right, give me the regulation.
Lordship, I am giving. The competent authority and the appellate.
Give me a minute.
Lordship.
No, this is the amendment. Where is the original regulation?
2010. Yes.
This is the only the
amended provision. This was the amended provision.
Give me the regulations.
Lordship. Yes, yes. Well, this is the amended provision, and I'm handing one thing, my lord, before Lordship. Kindly see. That is also one of the serious power which has been vested on the authority, my lord. That even, my lord, when there is an admission, even, my lord, without holding the, my lord, the disciplinary proceeding.
That is there. I'm not on that.
Yes.
On that, he may have a very difficult case. But let me see on the jurisdiction part. On the admission part.
Lordship, that I will demonstrate from the order of the division.
All right, I will come to you on the admission part. Let me see whether if you can.
And on my landlord has also not been able to prove, my lord, his case. And not only that, earlier the petition was moved. And the same point was dealt with by this honorable single bench as well as the division bench. That in view of this admission, he is not entitled to get any benefit of that. I have also brought that.
But that has been set aside. Earlier proceedings
Yes,
has been
yes.
set aside.
But no, that has been set aside. But subsequently, even the appellate court also please to hold the same point. That was not taken into consideration by the appellate court.
You are the officer or employee?
Employee, Lordship, I'm the cashier.
Employee.
Clerk come cashier.
And my lord, I have got the compact chart, my lord, 2010 and 2013 regulation. There's chart also, my lord.
No, who is the appellate authority?
I'm handing over. Behold,
Here.
2010 and 2013. Change and prior to change. Kindly see, my lord.
So the appellate authority in this case has to be the chairman.
20,
as per your regulation.
2013. 2013, can you see what I'm, right side? Left side?
Left side is the
Left side
2013.
2010. And the right side is 2013.
So we are on 2013.
Lordship.
Yes, 2013 is also chairman, where the general manager is the competent authority.
Yes.
So disciplinary authority should be the chairman. The appellate authority should be the chairman.
2013, can you see what 2013?
Yes, can you check up this? Here the competent authority is the general manager.
So the appellate authority should be the chairman.
So appellate authority should be the chairman. Right hand column.
And in case of officer, the board of directors is the appellate authority.
Yes. In case of chairman, it's the board of directors.
But in case of the employee, that is the last part.
In case of employee,
yes.
Who is the disciplinary authority?
Disciplinary authority is my lord.
Will be the general manager.
Yes.
And who will be the appellate authority? Chairman.
Yes. 2010.
So same person cannot be the disciplinary as well as the, that is the basic elementary principle. Appellate authority se bola ashe
Competent authority. The chairman is the chairman, where the chairman is the competent authority. The general manager, where the competent authority is decided by the board under subclause 2 of G. Last clause, but in case of the employee, general manager is the competent authority, appellate authority. Right hand, last part, last 3 lines from bottom.
Where is regulation 2.1? Show me the regulation 2.1.
Two, one.
No. Yes, this is III will not come into play. III will come into play in case of 21G3.
1G3.
Yes, so 21G3 is not in this case. So that will not come. Kindly check up. Kindly first come to the regulation 21G3. For that, that third column will apply. Third row of the second column, right hand column.
An officer not below the rank of scale 4
Yes.
in respect of the employee relating to Group B office assistant, office assistant and Group C, the appellate authority decided by the board.
Kindly see 3.
Yes, I'm
Yes.
reading 3, G3.
As
Who has the
decided by the board.
It
For
was the,
that this comes.
no, in that case, what the competent authority was, that has been disclosed here, defined.
Yes.
Competent authority, an officer not below the rank of scale 4 in respect of employee relating to Group B, office
Yes.
assistant,
Yes.
multipurpose, and Group C, office attendant, multipurpose, as decided by the board.
Yes.
Whatever
As
may be
decided by the board.
No.
For
Whatever
this
may be
case-
decided by the board. Whether, my lord, Group C, that is the office assistant, multipurpose, and Group C, office
Falls
attendant,
within which case?
multipurpose, as
It falls within this.
falls in this category, my lord. Yes, an officer not be, they will be the competent authority. Who will be the competent
Then
authority?
Then
Competent
general manager could not have been the disciplinary
competent
authority.
in that case,
Mr.
yes.
Hossain,
Thereafter, my lord, jail,
disciplinary authority and appellate authority cannot be the same
Thereafter-
authority.
absolutely. But only question is that whether, well, thereafter, my lord, the competent amendment, in the amendment clause, it has been said that the general manager will be the appellate authority, where the competent authority is decided by the board.
It does not fit in that.
Because decided by the board, because the board decided and delegated the power.
Show me that delegation. Show me that delegation.
That
The
has-
board in this case delegated the same person.
From the impugned order itself. The order impugned is the.
Show me the delegation. You are saying as may be delegated
Only-
by
only
the board.
delegation.
Show me the
Yes,
delegation.
in that case, I shall show. In that case, I shall show. Then I am taking one time.
Where is that in this order? You have said in this order. It has
In the
been
order, the signature point is that the as delegated. So this is here, but delegation of power, if your lordship asks
said.
me
No, where it has been said signature as delegated.
No,
Nothing has been
only
delegated.
signature point, my lord.
Show
The
me.
impugned order.
Yes, in
The
the
impugned
impugned order.
order.
Show me as delegated. Where it has been delegated? Nothing. Not a delegation.
Just a minute, my lord.
Yes. Appeal against an order of the general manager decided by the general manager. And you are saying it's delegated.
Yes.
Even if it is delegated, the delegation is bad. Show me that delegation.
Yes, well, then I am to take a section to that effect.
I will
so
hold
that
that delegation is bad.
I can
Everything, all decisions of that person will go.
Then, my lord, I have to take the section to that effect, that the delegation, whether it was given in writing or not, if that's so, I am taking the resolution, my lord.
Ashwin.
Also, may I continue with the admission part that has been decided, taken care by the division bench
What
or
of this
the
part?
adjourned? The admission, because the branch manager instructed him to take the
You are
responsibility.
giving up this point.
No, both the point,
Satisfied with that.
Lords.
Don't proceed any further. You'll be happy.
Because in the event the order of the appellate authority goes, the order of the disciplinary authority will remain. That I will satisfy on
Everything goes. It will start from the charge sheet.
Lordship.
No, according to you, that yes, the disciplinary authority order will remain.
Remain. So on that event, I have to
to-
satisfy from the admission part which has been.
Then the appeal has to be decided by the appropriate authority. I cannot enter into the merits.
Maximum that benefit they can take. But my lord,
Take
to that-
instructions on
Lord-
that. Then who will be the competent authority? I will decide the appeal to be decided by that authority.
Lordship.
Uh,
And I have also got one Supreme Court decision also, my lord, whether
says
the appellate was.
disciplinary authority will be the appellate
No, no,
authority.
no.
Show me that.
I shall show later on, my lord. I shall show later on. I have with this hand, my lord.
Sir,
But
what
at
are
the
you
time of
submitting? It's an elementary principle. The same authority cannot be the disciplinary as well as the appellate authority.
sure, but my lord, that is true. But whether it will be
What are you suggesting? That some person has changed in the meantime, so he will be the appellate authority.
only point, my lord, whether the same person
Disciplinary
is
authority X, Y holding the post of a general
Only-
manager, decided the disciplinary proceedings, then Y joins as a general manager, he will decide the appeal.
no, my lord.
That is what you are
No, no.
suggesting.
Only point, my lord, I beg to submit, my lord, that date also I shall submit to that effect, my lord, whether the person who decided the matter before the appellate authority after the subsequent amendment, whether that person is there or not, then the, my lord, the question of the, my lord,
I
violation of
accept your
justice will
submission.
go.
You need not take instructions on that. I accept your submission. Person has changed.
Lordship.
Even then, cannot be.
Then, my lord, let me take this to that.
The learned advocate appearing for the petitioner draws the attention of the court to the order of the disciplinary authority dated, what is the date?
Should
Dated
be,
25th or 28th?
28.
28th of September,
No, 28th of
January.
January 2022.
28th of January 2022. It appears from the said order that the general manager of Bongyo Gramin Vikas Bank,
Bongyo Gramin Vikas Bank.
Bongyo Gramin Vikas Bank acted as the disciplinary authority. First up, it appears that the general manager of the said bank acted as an appellate authority and passed an order dated
16 June
16th of June
2022.
2022. First up, the learned advocate appearing for the bank pressed for time to take necessary instructions in this regard. Yes, list this matter under the same heading, under the heading continuing matter on Monday date diye din. Next.
Grateful to
On
you.
Monday next.
Yes, coming Monday.
Grateful.
Or tomorrow you can come back.
No, my lord, it's not tomorrow.
Monday. Next.
একটু বলুন সেটা দেখাচ্ছিলেন জাজমেন্ট
47.
827 of 40.
Yes.
In this matter, I am for the petitioner.
You are for the petitioner. Yes. What do you want?
But compassionate appointment,
Compassionate appointment.
municipal employees
Compassionate appointment of
of the
municipality.
municipality. Yes.
There is a scheme for municipality. Compassionate appointment.
Uh,
Show me the
Yes,
scheme.
yes. And coming, my lord. First, your lordship kindly, my lord, the impugn order. From the impugn order.
Show me the scheme first.
Well, your
We
lordship,
go to the impugned order thereafter.
Yes.
Show me your
Sir,
consideration has to be pursuant to a scheme.
Yes.
Show me the
But
scheme
your lordship kindly see
governing the compassionate appointment.
in respect
of-
of the municipality.
Yes. Show me the scheme. Which scheme?
My lord, I will. My
And
lord-
you are carrying the Supreme Court decision also.
Yes,
out
yes,
there.
Tiwari. My lord, actually, the Tiwari's judgment, my lord, with due respect, my lord. Tiwari's judgment says that this memo relates to. Joseph Kedevan.
Yes, Mr. Basu, only your submission will be there is no scheme.
There is no
of the
scheme.
miss.
And that is there, my lord. On the last occasion, Lordship has directed me to bring that notification.
Base
I have with that.
26 September
Last occasion,
2005.
what
Yes, my lord. I think
My lord-
last time this lordship heard this matter, only
Yes.
adjourned this matter because of this notification was not at that point of time.
Which notification? Give
Yes,
me
my
that.
lord.
Notification 26 September 2005.
No,
They have
2005 has been
admitted.
superseded by 3rd December 2013, my lord.
My lord,
Wherein, my lord, it has been lastly. my
3rd
lord-
December
not
does,
applicable. It is
does not
government.
cover the municipal employees.
Yes.
Yes, my lord, it has been
But,
mentioned.
my lord,
It has been mentioned, my lord.
3rd December covers the municipal
Yes,
employees.
my lord. Yes, my lord. Superstition of all previous orders in respect of so-and-so West Bengal scheme for compulsory appointment 2013. My lord, it has been mentioned lastly, my lord, we may make it inform that extension of such benefit to the employees of corporation, undertakings, boards, local bodies, etc. are not under consideration of the government at present.
So, what does it mean?
me.
So municipality is there, my lord.
Oh.
And not only that, my lord, the
Yes,
judgment of
It had to be
Devbhuta
ascertained.
Tiwari, my lord, considering Devbhuta Tiwari's judgment also was seen, my lord,
Yes,
considering all this, my lord,
This is the, my lord,
court
the
holds, my lord,
judgment
that
251.
the court holds, my lord, ultimately, my lord, may I just read, my lord? This is the controversy regarding applicability of the circular 97 EMP 6 June 2005 to employee of local authorities such as municipalities, because circular number 142 EMP dated 1st November 2007 provides in no unclear terms that 97 EMP would not be applicable to the employees of the local authorities. Now, my lord, in thereafter, my lord, the court holds, my lord, if circular number 301, 302 EMP 303 are to be read so as to cover all establishments of the Act of 1999, then 97 EMP dated 6 June 2005 should provide for appointment in the establishment covered by the Act of 1999 concerned. It does not do so. Therefore, circular number 301 EMP, 302 EMP and 303 EMP cannot be held to be applicable to the local authorities. The existence of the policy issued by the state government in sine qua non for making appointments on compassionate basis. Vide Mumtaz Hussain to judgment has been referred. The appointments must follow the stipulations made in the policy. It is therefore no brainer that in the absence of a policy governing compassionate appointment to the post under local authority, no appointment could be made to such authority on compassionate grounds. Having held that circular number 301, 302, 303 cannot be applicable to local authorities, we are unable to affirm the findings of the division bench of the Honorable High Court to the effect that given that circular number 301, 303 and 303 were not specifically withdrawn, they would continue to remain applicable, and therefore compassionate appointment in respect of municipalities would be governed by the scheme under circular 301, 302 and 303 MP. We therefore of the view that the liberty granted to the local authorities in circular number 142 MP to formulate their own scheme for compassionate appointment is an acknowledgement of the fact that there was no policy existing to govern compassionate appointment to the post of under local authorities.
Yes. Yes.
This is the latest judgment of.
Yes. My lord, that is there. It is well not, my lord, the judgment. Your lord,
Show me after that there is a scheme.
No, your lord, kindly come, my lord. Kindly come, my lord, the impugned order. From there,
you have a copy of that judgment.
Yes,
and
yes.
From this memo, which paragraph you are saying that it's
Memo, my lord.
Actually,
a copy was given. The document which was given to me, my lord. I can just.
আরে তুমি ওই 26 সেপ্টেম্বরটা দাও না ভাই 26 September 2005 memo issued by the
there, my lord, superseding all the previous memos. It has been mentioned.
mentioned relying the ঠিক আছে আমাকে একটু বলতে দাও তারপর আমি বলে দিচ্ছি দেবব্রত তিওয়ারি জাজমেন্টটা অ্যাকচুয়ালি আসল জিনিসটাই দেখায়
না considering everything, Gobindo Hajra and all, everything has been considered. Gobindo Hajra has been turned down by the division bench in Devbhuta Tiwari, and state has.
This is in superstition of all previous
notifications.
Yes,
my lord.
Yes. Yes, this he has given. Yes.
My lord, your lordship kindly come page 41.
So possible, do you have a copy of the Supreme Court judgment?
I shall, can I give him, my lord?
Yes.
এই ইমেলটা
আচ্ছা,
নিয়ে তো।
এটা কোনটা?
3rd December.
3rd December, yes.
So after the Supreme Court has decided,
My lord, your lordship kindly see, my lord,
what
your
can a
lordship,
single judge of a
Ma-
high court do?
no, your lordship kindly see.
The appeal of the
Just-
state.
No,
The appeal of the state.
all right, my lord, appeal of the state, your lordship kindly see. My lord, with due respect, my lord, according to my reading, my lord.
Following that, I have delivered a judgment.
ওখানে বল
Following the
ছিল।
Supreme.
Yes, your lordship, your lordship kindly allow me to submit, thereafter your lordship delivered judgment. I am not, my lord, standing in the way.
ইমেলটা দিয়ে দেন।
Page 41, your lordship kindly. Page 41. What is their own admission? That they have got the policy. 41, last paragraph.
Mr. Sau, that will not help. I'm
Yeah, yes,
asking you,
it will help.
show me, even I cannot go by that admission.
Yes.
Show me that there is an existing scheme.
Your lordship kindly, from their own, my lord, the recording, I will, my lord, try to prove that the scheme is there. That scheme has not been brought to the notice of the Honorable Court.
Yes, show
Honorable
me which
Supreme Court.
scheme, which scheme.
Yes. Whereas approval of appointment, have your lordship got it? Last paragraph. I am reading page 41. Impugn order. Yes. Whereas approval of appointment on compensatory ground was accorded by the director of local bodies following the order vide number such and such dated 26 September 2005 issued by the then Municipal Affairs Department. But after issuance of memo number 251 EMP 3rd December 2003 from the Labor Department, by which all the previous order in respect of compensatory appointment was superseded. There was no existence of memo number such and such 26 September 2005. This is one. Hence, when the further petitioner died on such and such, when the proposal of the chairman Arambagh municipality received by the director of local bodies, there was no existence of GO dated such and such 26 September 2005.
You are challenging this order?
Yes, I am challenging this order. Your lordship, allow me to read, my lord, I will show you. There was no existence by which the local bodies used to accord approval to the municipal employees under die enhanced category. So I am pausing here moment. My lord, they have admitted that there was a circular scheme or circular or government
of 2005.
2005, yes.
And they have also admitted
Yes.
that it has been superseded in 2013.
They sought for clarification. Next paragraph, your lordship, kindly come. Kindly allow me to read, thereafter it will be clear. Therefore, the then director of local bodies, West Bengal, could not examine the proposal of the chairman of the municipality for approval of appointment under die enhanced category. Next paragraph, that is vital. However, clarification was sought from the Labor Department whether order number 251 dated 3rd December 2013 would be applicable to the municipal employees or not. Labor Department asked the same question to the Finance Department. On 26/12/2013, Finance Department informed that benefit of the order of the Labor Department by memo number will not be applicable to the municipal employees. If this is the, my lord, the answer, certainly, my lord, the memo dated 26 September 2005, which was used, they have admitted that it used for according the compensatory appointment to the Municipal Affairs Department. Still remain in force. They have said by
No, it has been superseded.
How?
2013.
2013, but they have sought for clarification whether it is superseded or not. They have answered that this circular, this government order dated, my lord, the 3rd December 2013 is not applicable to the municipal employees. It is in respect of the government employees. First paragraph it is said. Your lordship, kindly see. First, the government order of 3rd December 2013, your lordship, kindly see, it applied to the state government employees. So it is a clarification that it, my lord, it is applied to the state government.
Order to the division bench up to Supreme Court.
Thereafter,
there you can get it unsettled.
All this issue has been taken up before the single bench, then division bench, then
challenge before the division bench. Supreme Court will be binding out. Then thereafter, challenge. You can raise all these points there.
Your lordship, kindly see, my lord, I have brought the judgment of the justice theory judgment. Your lordship, kindly see. What my learned friend is. First, your lordship, kindly see the memo number 303. I have handed over to your lordship.
Memo number
memo number 303. It has been considered. With due respect, my lord, to the...
Ultimately, what is the court held, my lord?
Darao na bhai. But I have handed over a supplementary affidavit wherein in the year of 2006, your lordship, allow me
2006,
to...
the document which has been filed, my
yes,
lord, at that
compensate
point of
appointment has
time,
been given.
2005 circular was at that point of time there.
303 was considered by the Honorable Supreme Court.
Yes, my lord.
Your lordship, kindly see how it has been considered. Your lordship, kindly see.
Give me a
Yes,
copy of
yes.
the judgment.
Yes, I have brought it. Your lordship, kindly see. Huh?
Was it considered or it was not considered?
Considered, your lordship,
Wrongly, according to you.
yes.
So go before the Supreme Court.
Because, my lord, your lordship, kindly just see. The Honorable Supreme Court says it has been explained that this EMP 303 is applicable to the state government employees. It will not be applicable to the...
Give me a copy of the judgment.
Last I am just marking kindly. Just relevant part I am. How it has been dealt with. 303. Your lordship, kindly see.
303.
Page 75. Your lordship, kindly see. The reason. Circular number 303 EMP provides that any department which has vacancy...
Which paragraph? Which paragraph?
Paragraph mana I. Paragraph.
Yes, I've got.
Have you got?
I've got.
Yeah. Circular number 303 EMP provides that any department which has vacancies exempted category of post will provide employment to the wife such dynamic. The word is department would indicate that the said circular would govern compulsory appointment of department of the state government, not local authority. Not local authority. Now, your lordship, kindly see the what the 303 says. 303 says the local authorities, but it has not been properly dealt with, my lord. Your lordship, kindly see.
এই দরকার নেই জসে পেয়ে গেছে কপি পেয়ে গেছে
হ্যাঁ দিয়েছি
এটা বলবে তো তখন তোমার কাছে কপি আছে
So according to you, this 303 should apply to your case.
Yes, your lordship, kindly come. Here says the local authorities. I am reading. Your lordship, kindly allow me to read. 303 in your lordship, I have handed over to your lordship. Your lordship, kindly see. According to my ability, my lord, I am arguing. Your lordship, kindly consider it. In exercise of power conferred under the section 3 of the West Bengal Regulation, recruitment of state government establishment of public undertaking, statutory bodies, government companies, and local authorities under Act, the governor is pleased to prescribe the following procedure for filling up the vacancy of exempted category. The exempted category die in earnest. Now I am coming to the local authorities. My lord, your lordship, kindly see the Jail Clauses Act. I have brought it. Your lordship, kindly see what says the local authority. By this act, my lord, the local authority...
Oh, I cannot go into that in view of paragraph 16.4 of the Supreme Court.
But the local authority, my lord, actually, my lord...
You have to travel 2 steps up.
My lord, your lordship, kindly what I am submitting, your lordship, kindly recorded judgment, my lord, then it would be tested. Local authority means the municipal authority.
Yes, yes. I'm not disputing that. Then the petitioner.
The findings is, my lord, probably perverse.
But Mr. Shaw, this judgment is against.
Yes,
so
that is true.
I'm bound by this judgment.
That is true. But your lordship, kindly see the explanation.
I cannot go into that.
Then your lordship, kindly, yes, I have understood. Your lordship, kindly record my submission and kindly deliver a judgment. It should be tested and it will go up to Supreme Court. Actually, this judgment should be reviewed. It has not been properly explained.
To that I will immediately sign this order. The petitioner has challenged the order of the Director of Local Bodies,
Totally bhul judgment.
West Bengal, dated. What is the date of this order?
And one thing is, my lord, just one
30th of August 2022.
Yes.
Dated 30th of August 2022. by the no, in this
Eligible.
writ petition. No, it says 16th of August.
My lord,
Where is the
it has
date?
been communicated on 30th August
No, where
2020.
do I get the date of 16th of August?
Hearing was held on 16th August,
16th.
my lord. It has been mentioned in the letter, my lord.
Oh,
Page 40.
acha, ki bollam?
Nagi?
Order. No, order which was communicated.
Communicated.
Ki bollam? Of the director of local bodies pursuant to
भूल judgment.
a hearing held on
Huh?
16th of August 2022, which was communicated to the petitioner, while later dated August 30, 2022, in this writ petition.
রিভিউ করতে যাবো
By the said order,
এইটা হোক
the prayer for compassionate appointment of the petitioner stood rejected on the ground that there is no policy for there is no policy for compassionate appointment to the family members of the deceased employee of urban local bodies under Urban Development and Municipal Affairs Department. Mr. Shaul, honored advocate, appearing for the petitioner, strenuously contends that the notification being number 303-EMP-1M-10/2000 dated 21st of August 2002 enables the deceased enables the family members of the deceased employees of urban local bodies to claim compassionate appointment. Mr. Basu Mollik, learned advocate appearing for the state, submits that the said circular dated August 21, 2002, as well as all previous circulars, has been superseded by notification being number 251-EMP dated December 3, 2013. He placed reliance upon a decision of the Honorable Supreme Court in the case of State of West Bengal versus Devobroto Tewari and others, reported at 2023 within bracket 3 CHN within bracket SC 52, in support of his contention that the circular number 303 EMP cannot be held to be applicable to local authorities. Paragraph. Heard the learned advocates for the parties and peruse the materials placed. The director of local bodies in the order impugned has observed that after issuance of notification being number 251-EMP dated 3rd December 2013, all previous orders in respect of compassionate appointment was superseded, and there was no existence of order dated 26th of September 2005. The Honorable Supreme Court in Devobroto Tewari within bracket Supra has held that circular numbers 301-EMP, 302-EMP, and 303-EMP cannot be held to be applicable to local authorities. First up, The Honorable Supreme Court further noted that liberty was granted to the local authorities in Circular number 142-EMP to formulate their own scheme for compassionate appointment, which is an acknowledgement of the fact that there was no policy existing to govern compassionate appointment to posts under the local authority. The Honorable Supreme Court held as follows. Bole, এই প্যারাগ্রাফ 16.1 থেকে না সেটা উঠতে হবে ওইখান থেকে দেখে নিন উনি তো বাদ করেছেন ওখান থেকে তাকে করে দেওয়া যায় কিনা 16.4 ঠিক আছে this court therefore holds that there is no scheme for compassionate appointment to the family members of the deceased employee of urban local bodies. Full stop. It is well settled that existence of a policy is a sine qua non for making appointment on compassionate basis. Full stop. In the absence of any policy decision of the government enabling the family members of the deceased employees of urban local bodies to claim compassionate appointment, this court is of the considered view that the petitioners do not have any right to claim compassionate appointment. First up, for the reasons as aforesaid, the order of the director of local bodies do not suffer from any infirmity warranting interference under Article 226 of the Constitution of India. For the reasons as aforesaid, the writ petition stands dismissed without, however, any order as to cost. Urgent photostat certified copy.
One prayer I will
If it is service filed in court today,
one prayer I will make for adding one sentence, my lord. My lord, they have admitted that the memo number 251 dated will not be applicable to the municipal employees. It is their own admission. Kindly record this, my lord. It is their own admission. Your lordship, kindly see. Page 42, paragraph. However,
clarification was sought
from the finance department.
From the labor department, whether such and such would be applicable
or not.
Yes,
labor department asked the same question. Finance department informed that benefits will not be available
to the municipal employees. Your lordship, kindly record this. It is their own admission that this circular is not applicable to the municipal employees. 3rd December 2013.
Will that help you? I can record that.
Yes, it will. But you are kindly record it. This is the finding. This is the finding.
বলেছি না যেখানে ওই ডিরেক্টর অফ লোকাল অবজারভেশন সেখানে লিখে দিন আরেকটা লাইন
Yes.
It has been further observed by the director of local bodies in the order impugned that the finance department has informed that the benefits of the order of the labor department vide number 251-EMP dated 3rd of December 2013 will not be applicable to the municipal employees. I've recorded that.
Yes.
Get fellowship. Yes, call the next matter.
My lord, this judgment, when it has not been, with due respect, it has not been properly assessed.
Mr. Shaw, my hands are tied.
That is
I'm
true.
bound by that.
I think, my lord, I am able to convince your lordship that local authority means municipality.
Mr. Shaw, I was hearing a matter when the appeal before the Supreme Court was pending.
Yes.
So I was about to pass an order on the basis of the division bench judgment.
Yes.
An adjournment was taken.
Yes.
That it is likely to be heard very soon.
Yes,
it was adjourned. On the adjourned date, this order was brought to my notice.
Actually,
and I accordingly, following this, I have passed the order.
Actually, these judgments should be reviewed.
This Choitali Bhattacharya was appearing in that matter.
These judgments should be reviewed because local authority means municipal authority.
Extension আছে তো এই 5 মিনিট আগে ডাকবো
Yes, yes. Sure.
3:25 Yes, call the next matter. I will see that you get the server copy very soon.
Yes, yes.
Yes. Next, call the next matter.
Milord. 48. Milord, I appear for the petitioner, Milord. A superannuated employee seeks disbursal of retirement benefits. Gratuity paid.
Why it has been withheld? Disciplinary proceedings.
No. They say that an office memo overrides the statute. Yes. An office memo was handed over.
It is appearing for the authority.
I'm
Which authority has withheld?
This is the West Bengal Housing Federation. Yes. West Bengal Housing Fed.
You are representing.
Madam, I'm appealing for the respondent number 6.
Respondent number 6 is Life Insurance Corporation.
Yes, my lord. 6 has got nothing to do with it.
Mr. Bordon, who is the effective respondent?
House Fed. 3 and 4.
Who is representing them?
Miss Jui Chakraborty was representing them earlier.
Jui Datta Chakraborty, Kakoli Noskor. Yes, show me the impugned order.
No, there's no impugned order. Mala, kindly seize. Kindly seize.
No, you have paid for release of your
yes.
retirement benefits.
Yes.
And is it still under consideration or it has been rejected?
No, they have said they cannot. Kindly seize the report.
Where is that?
They have filed a report, my lord. They have filed
a report
in the form of an affidavit.
Yes.
On behalf of the opposite party number 4. At Mullard, page 6, kindly seize. They have disbursed 12 lakhs out of my claim of 19.
Report.
There's a report, Mullard, which is a part of an affidavit affirmed on the date of that.
Yes, report in the 2-page affidavit.
Yes.
2-page report.
No, 2-page report. No, there's an annexure as well.
Baba, yes.
Page 6.
Page
6. Annexure R1. Excerpts of the proceedings of the meeting held on 18/6/2020.
Yes.
Of the Board of Directors of the West Bengal State Cooperative Housing Fed Limited at such and such, to discuss about the upper limit of gratuity for the staff of House Fed. The Honorable Chairman of House Fed pointed out that the State Cooperative Union has implemented the ceiling of gratuity up to rupees 12 lakhs for the office staff as per directive of the Cooperation Department, Government West Bengal. The members present discussed the information given by the Honorable Chairman and unanimously resolved to increase the upper limit of gratuity of the employees of House Fed up to 12 lakhs in view of the said directive of the Cooperation Department, Government of West Bengal, 12 lakhs. But employees representative has raised a note of dissent in this regard. So this is what they say, not more than 12 lakhs. Well, kindly seize now the statute.
You have got 12 lakhs.
Yes, I want 19. That's what I'm entitled to.
19.
So they have withheld the balance 7 and kindly seize 4 3 for once.
Other things you have got.
And leave encashment. Both are left.
Well, what is the reason for leave encashment?
No reason.
What they have said with regard to the leave encashment?
Nothing.
That has just remained unpaid.
Option of leave encashment, they have said in page 3, paragraph I. The option of leave has been stopped by the decision and a note of the erstwhile chairman since 2013 due to non-upgradation of leave.
To that, my lord, we have taken out an exception, and my lord, my lord, will kindly see annexure P7 to our exception, page 8.
What is the meaning of this? I could not make out anything. Due to non-upgradation of leave in the service group.
No one knows. They believe it's the God-gifted right to withhold someone's retirement benefits. They convene a meeting.
What is your stand in the exception?
Well, kindly seize.
With regard to the leave encashment?
Well, kindly seize the leave encashment portion, my lord. Kindly seize annexure P7, page 8.
Of the writ petition?
No, my lord, this is the exception from an affidavit.
Exception, page 8.
It's 25th of November 2009.
Yes.
It's from the Joint Secretary Government of West Bengal to the Chief Executive Officer of the West Bengal House Fed. Kindly seize, the undersigned is directed to state that to streamline the process of activity of House Fed, the management of House Fed would take the following steps. Kindly take 7. To ensure submission of leave applications by employees and officers on a regular basis. So, my lord, they have a policy in which leave encashment is to be paid. And leave encashment is to be given to them after proper calculation of leave availed by them. So it cannot be that they don't have a scheme for leave encashment.
But it will be stopped if you do not submit the leave applications regularly.
Well, where is that case, Manoj? Is there any affidavit on record?
No, but what is they have? I think they have tried to make out this case in the report. Paragraph I.
It is
No.
their departmental.
It is paragraph 4.
Page 3, which the paragraph which I was referring to.
The option of leave encashment has been stopped by the decision and/or a note of the erstwhile chair. Can they do it?
Non-upgradation of leave in the service book.
Can they do it? It's since 2000.
According to them, it's their fault. They have not recorded that.
2000. And I showed this notification which I was showing was 2009.
Yes, but the Bordon, no one is appearing.
Well, put them on notice and come back.
Ashun. The learned advocate for the petitioner, Mr. Bordon, learned advocate appears for the petitioner. First up, none appears for the respondents, excepting the respondent number 6. Excepting the respondent number 6. The learned advocate on record of the petitioner is directed to communicate the next date of hearing to the non-appearing respondents and file an affidavit of service on the next date.
Monday.
Same heading. Next.
No. I'm grateful.
Yes.
49.
Your Lordship, I'm appearing on behalf of the petitioner, Your Lordship.
Yes.
Your Lordship, this is a matter pertaining to an order passed by the adjudicating authority. I'm being led by Mr. Shayan Sinha in this matter. Your Lordship,
What do you want?
an adjournment of not this week, Your Lordship.
Not this week. Next.
Deeply obliged.
50.
My lord, I am for the state, paying for not today, my lord.
For the petition, I mean.
Yes. Not today. Next.
No, my lord, it's actually short password, just outside.
What is short password? You have a 3.
Already have this.
Yes. Yes, you are for the state. Why are you going back?
Paying for not today, my lord, actually.
Yes.
Here the petitioner has claimed for the pay scale of the instructor, my lord, since 2006, my lord, from 2nd August 2000.
Regularization of service.
Regularization of service. And also pay scale, my lord.
Why regularization?
Lordship, what had
You
happened?
are a contractual employee.
No. He was initially appointed as a laboratory assistant. Thereafter, my lord, the state government had introduced an industrial training service, industrial training trade course, my lord. And in 1990, since 1991, my lord, he was directed to take the classes of workshop calculation and science under the ITI course. He was required to make, he ought to have been given a scale of instructor. That was not given. Thereafter, my lord, the first writ petition was filed. This is the 3rd round of litigation. Now, after the first writ petition was filed, your lordship will find, my lord, at page 40.
Yes.
Lordship, 1 second.
Yes.
Lordship, the order is at page, my lord, 41. Order dated 16th of May 1997, my lord.
So according to you, you are carrying on these duties of instructor.
Lordship, until my retirement.
As per their direction.
As per their direction. And my appointment was sought for approval, my lord, from the department. Thereafter, I had retired in December in 2018. My lord, I'll have to take instruction as to the exact date of retirement. I know it's 2018, but I shall take the instruction.
All right.
Lordship, can I come tomorrow? Can I come?
All right. I can take it. Yes. Yes, call the original side matter.
Before original side, item 51, my lord, there is a direction to file exception to the report that has been filed by the answering respondent. Yes, my lord.
Yes.
I am praying for 2 weeks extension of the time to file exception, my lord. But as because the advocate on record, Mr. Nilesh Gupta, has undergone kidney tumor operation.
Next week. Make your exceptions ready in the meantime. Yes, call the original side matter.
May it please your lordship.
Who is your other side?
We have caused the service of the notice, Mr.
My lord,
Siddharth
I'm
Shroff.
appearing for the respondents, my lord.
The email mentioning notice is there.
You have given notice.
Yes, yes, yes.
My lord, am I audible? My lord, I'm appearing for the respondents, my lord.
Yes.
This is my application which was earlier filed, terminating the mandate of
You are not visible.
My lord, the video option has not been provided to me by the host, my lord. My lord, only audio access has been given to me.
I'll not take much of a time. This was an application filed by us on a unilateral appointment at the instance of the respondent, and hence we
So
moved
the
the
interim order was till 8th of January 2025.
Yes. We mentioned it yesterday. It was supposed to come to be mentioned today. It was appearing today to be
matter
mentioned.
is appearing in the list.
Yes. As item number 5 to be mentioned in Justice Shorka's list.
As to be mentioned.
To be mentioned. For extension of interim order.
Yes. That I follow, but when it is supposed to appear for hearing?
So it's supposed to appear for hearing in 2nd January. It's appearing in the monthly list.
It's appearing in the
monthly list. Item 64.
All right. So I'm extending till the end of January.
Great.
This matter was mentioned, citing urgency. Paragraph, the learned advocate, the petitioner submits that you are appearing.
Yes, my lord, I'm appearing for the respondents, my lord. I have one short prayer, my lord. Since then, I have filed a Section 11 application, my lord. My lord, if that application can only be tagged with the present application, my lord, that is the only prayer.
I'm only directing the matter is in the list. It will retain its position. I'm only extending it till the end of January or until further orders, whichever is held.
My lord.
After hearing the learned advocate for the petitioner and the learned advocate for the respondent, the interim order already passed on 16th of December 2024 is extended till the end of January 2025 or until further orders, whichever is earlier.
Grateful.
Let the matter retain its position in the list.
Grateful, Your Lordship.
My lord, it is not in the list, my lord. Let it be listed. Urgent matter, my lord.
Under original side?
My lord.
Original side or appellate side?
Appellate side, my lord.
Appellate side mentioning was done. Yes, call the appellate side matters. Anyone is there in the appellate side? 54. Who is your other side?
Chandni is my other side, and also.
Can it be finished?
I am filing the affidavit in opposition.
We can start from tomorrow with my lord seats. So we can start from there.
I mean 53.
54.
Which item?
I am filing the affidavit in opposition.
53. Where is your other side?
I'm 53. Let it be taken up next week, my lord. Kindly, my lord, pass an order, my lord. Let it be taken up
tomorrow only.
Or day after tomorrow. Monday, my lord.
I'm not fixing any date. I'm not.
My lord, I am mentioning an extreme urgent matter, my lord. Let it not in the list. Not in the list, urgent matter, my lord.
What is the urgency? Hearing matters.
Urgency, he will retire after 6 months, my lord.
Not the urgency.
But tomorrow it will. Serial number 3. Nale by chance. Take.
সময় দেবে না দুটোর সময় মেসেজ করলে হ্যাঁ থাকে